Hi, everyone, and welcome to the second webinar for those who've been invited to submit a final application for CLEAR's Digitizing Hidden Collections, Amplifying Unheard Voices. I'm Jane Larson, Senior Program Associate on the CLEAR Grants team, and today's session will be focused on rights, ethics, and reuse. We're going to start off with some introductions, first to the platform and then to our presenter for today's webinar. Here are some notes about using Zoom during this session. A live transcript is being generated if you'd like to utilize it. To turn on this feature, you can click the CC Show Captions button at the bottom of your Zoom window. Attendees will be muted throughout the presentation. However, you're welcome to use chat for general introductions and conversation. If a chat box isn't already displaying on your Zoom screen, you can hover your mouse toward the bottom of the screen and open it manually. In order to send a message to everyone, remember to change the default from all panelists and hosts to everyone. We ask that you use the separate Q&A box to ask questions. This can be opened the same way as the chat box. Because we have limited time together, please feel free to follow along with the questions as they come in and upvote them to let us know that it'd be helpful to you to have them answered live. We'll do our best to answer all of the questions live. But we'll also share written responses to all questions alongside the recording. This session is being recorded, and so the slides, Q&A recording, and transcript will be made available on the Apply for an Award page on our website in the next 2 weeks. Our team would like to center today's conversation by acknowledging that as residents of the United States, we are speaking to you from unceded land of many Indigenous peoples. I'd like to respectfully acknowledge and recognize the original and current caretakers of the land, water, and air where I live, the Shawnee and Osage peoples, and all their ancestors and descendants. I'm grateful to have the opportunity to live and work on their homelands and ask you to join me in acknowledging all Indigenous communities, their elders, both past and present, as well as future generations. May this acknowledgement remind us of our shared commitment to beginning the process of working to dismantle the ongoing legacies of settler colonialism.
During today's session, our host will dig into rights, ethics, and reuse. We've allotted 90 minutes total for today, and the speaker will pause at the halfway point at about 2:45 p.m. Eastern Standard Time for a quick break during their content. We're hoping for an engaging time of conversation around identifying rights and ethics concerns in original materials, assessing risk, and determining appropriate access with creators and community in mind. The plan is to reserve about 25 minutes for Q&A near the end of this session. Both the session host and CLEAR staff will be available to answer questions at that time. So while you may pose questions throughout using the Q&A box, keep in mind that we won't get to every question as it's asked. Staff will be keeping track and will circle back to any unanswered questions during the dedicated Q&A. Okay, let me launch this real quick. So we want to launch a quick poll to gauge how you're feeling about today's topic and today's session. You'll learn more about the skills and strategies you need to complete the following application tasks: project details, rights, ethics, and reuse tasks, along with the upload rights, ethics, and reuse appendices. Hope they're still going.
You more trickling in. I think we're good.
All right, let's end that. So now we're going to be happy to turn things over to Sandra. This is Sandra Enimil, who is the Director of Scholarly Communication and Collection Strategy at Yale University Library. We'll take just a moment to let Sandra share her slides and get oriented. And as they do that, please remember that we'll be breaking for 5 minutes at the halfway point.
Are you all seeing my slides? No?
See them, but
Sandra, we can see them, but they're not in slideshow. They're small.
they're small. There we go.
Okay. All right, great. Okay, hello everyone. My name is Sandra Enimil, and as Sharon noted, I'm the Director for Scholar Communication and Collection Strategy at Yale Library. I have my email address there if you want to reach out later after this as well. I'm going to turn off my camera and I'll turn it back on when it's time for the Q&A portion. So, as you all know, I'm here to talk about rights, ethics, and reuse as you all are considering the applications that you're going to put forth for the grants that you're considering. And it's really meant to provide some information around copyright to help you think through what might be some possible issues in regards to copyright, cultural heritage considerations, what specific communities might be involved or interested or part of your collections, and how you can reuse the content if this material is not necessarily owned or created by your particular institution, and what are some of the things that you need to think about and consider as you're working on your application. So first, I hope everybody is dealing and managing this change of time well. I am still kind of struggling, but hopefully everybody is back on the right time zone and in your minds as well. I always have to start with a disclaimer whenever I'm talking about legal topics. This is information about legal topics, so it will include information about copyright, but it is not considered or should not be considered as legal advice for your specific situations. And so you may need to, or may be important for you to talk to someone who might represent you, or a lawyer who might be able to take in some of your interests and your very specific questions that you might have. So just want to let you know this is information about legal topics, it's not legal advice. I also like to just make sure that everybody's clear on what we're talking about. So we're going to be focusing on issues around cultural heritage, so rights, ethics, your responsibilities, and how you might reuse materials that you didn't create, but want to make sure that you understand what the world of intellectual property rights and how it includes copyright, but that's not the only thing. Trademark has to do with how you recognize brands, so symbols and things that are used as or associated with a good or service. I have the bullseye from Target there, so when you see that, you know that means Target. The sales tag from Best Buy, the golden arches for McDonald's, these are all things that indicate a brand, a trademark that is used to show you that a good is related or associated with that particular mark. Patent is for new and useful discoveries or improvements. So you might also see patents for inventions and for things that are going to be useful for society. Trade secret includes formulas and processes, things that are not readily known or ascertainable, although with the internet, there's a lot of things that have been figured out over time that used to be top secret, but it is something that is meant to be, that is related to a particular brand and their way of putting out their products into the world. An example of this, which used to be my go-to example, I need to find another one, but the secret sauce on a McDonald's Big Mac, that used to be secret, so people didn't know what it was. But although I've heard that it's basically just Thousand Island, but whatever, the internet has definitely revealed what that secret is, but it used to be known as a trade secret, which was something that was part of one of their biggest selling items, the Big Mac. And then, copyright is what we're going to be talking about today. Just giving some background and information on copyright and some particular parts of copyright that could be helpful as you consider things that are part of your collections and what you're hoping to utilize as part of your grant application. So going to go back in time just a little bit to give like the international and historical perspective on copyright. In 1710, the Statute of Anne was put into effect in England. And it has copyright term, which is a new way of thinking about how things are created. And it gave protection to the creators or authors of copyrightable content for 14 years. And then that term was renewable for another 14 years. And the author had to still be alive in order to receive that benefit. With the creation of this statute, the public domain was created. So there's a social quid pro quo that comes about because authors and creators are given a certain amount of time to be able to make their money, do whatever they need to do, exploit the thing that they created in any way that they feel, and allow others to do it on their behalf. But they are able to make uses of the things that they created. And then after the copyright term expires, it is available to the public to also to make use. And the real benefit of the public domain is that people are able to get access to this content and then also make their own new creations and new things, maybe building on this material or just from the inspiration. 1886 is the creation of the Berne Convention. At this time, the United States did not join, but it was created by other parties around the world. And it is creating this convention that says everyone who is a part of this convention will respect the copyright laws of every member that's party to the terms. It defined the copyright term of life of the author plus 50 years. And so we get out of like all the various ones that people have, and they have a minimum term that you have to be able to be a part of the convention. You have to have life of the author lives, dies, and then for 50 years after that, the works that they create are still covered by copyright. And this may be important for some of you in your collections. If you have works or content from people, from authors who are no longer living, knowing when they passed away is important to know, like when their items would go into the public domain. When the United States became its own entity, became its own country, one of the first things that were done after the Constitutional Convention was to create a Copyright Act. And they wanted to create something that would have protections, the same as the ones that were available in England. Essentially, they use a lot of similar terms and phrases to be able to have protections for people who are creating content, creating copyrightable content at that time. And again, it was the same kind of idea where there were incentives for creators, and there was also the balance of the public domain. So just as with the original Copyright Statute Act, Statute of Anne in 1710 and 1790, they had the same idea where creators would have a limited term to be able to exploit their works. And then once the term ended, it would be available for the rest of the public to utilize. I wanted to show all of these different milestones in US copyright law. These are by no means the only things that were happening with US copyright law, but these were some of the major acts that happened over the time, from the founding of the nation to the first Copyright Act to revisions. With each of these revisions, more things were included in copyright. And so we started off with textual works, and most of those things were covered, then eventually started adding things like pictures, sculptures, film, and software. Eventually, with each and every revision, more things were made to be included in copyright. You'll note here the change from the term being 14 years and renewable for another 14. And 1790, you had to be still alive in order to renew the term. In 1831, they add in a provision where that your heirs could then be eligible to still benefit from the thing you created. So you did not have to be alive still for copyright to still be in place. 1870, copyright matters moved to the Library of Congress, where Copyright Office still is. And then increasingly, the terms got longer, so 28 years, 1909, plus another 28 years if renewed. 1976, in 1976, we were trying to get into the Berne Convention. And so in preparation for that, the term had to change again to the minimum standard, which was available through the Berne Convention, which was life of the author plus 50 years. 1998, Sonny Bono Copyright Extension Act. Some people also call it the Mickey Mouse Copyright Extension Act, which added another 20 years, which now makes the term, which is the current term for copyright, life of the author plus 70 years. So that is the current term of copyright. The US is now a part of the Berne Convention, and so we respect other people's copyright laws. They respect our copyright laws. In 2018, the Music Modernization Act came into force really to try, one of the main goals was to federalize pre-1972 sound recordings and to address issues related to downloading, streaming, and producer royalties. One of these, one of the great things, which I'm going to talk about a little bit later, is the creation of the public domain for sound recordings. Until this point, it was a bit of a mess because everything is regulated by the individual states. And so now that there is federal protection, it creates a public domain for these. In 2020, during the pandemic, the Copyright Alternative and Small Claims Enforcement Act came about. So the Copyright Claims Board, which is a tribunal, not a court, voluntary tribunal, where for cases of copyright infringement, where the claim is less than $30,000, could go through this tribunal. And this is to try to help rights holders who may not have the funds or really the time, resources, all the things that are needed to mount a federal copyright infringement case. And so this is, again, a voluntary tribunal, and there's a lot to be said about that. So as I mentioned, when I talked about all the different revisions and times that copyright has changed in the United States, that each revision brought in new things that could be covered by copyright. And so you see some examples of things here in the image: architecture, sculpture, literature, pictures, film, music, software, books, of course, drama. All these different things are meant to be a floor, not a ceiling, for what can be covered by copyright. There are many things that weren't anticipated once the most recent revision came about with 1976. There are things that didn't exist then that are still covered by copyright because they fit the parameters still. As a creator of copyrightable content, there are 6 rights that you have that are listed out in US copyright law. So you have the right to reproduce your work, to make copies. You have a right to prepare derivative work, so to take your poem and make it a song, take your book and make it into a film. You have the right to distribute your work, publicly display, and publicly perform, including publicly performing a sound recording via digital audio transmission. So these are all the rights that you have, and you have them until you transfer them away and give them to someone else, or you can keep them and license certain rights to specific people for specific things. So you keep the rights and you can authorize others to make uses of that content under your direction or however you want to do it, or you can transfer rights to other people. And once you transfer those rights, you no longer are the rights holder. You would still be considered the creator or the author, but if you transfer your copyright, the person you transfer to would then become the rights holder. So the things that are not protected by copyright, works that are not fixed in a tangible means of expression. So if I were just speaking to you face-to-face in person and giving this presentation, me just speaking to you, there can't be copyright in that because it's not fixed in a tangible means of expression. The PowerPoint, however, can have copyright protection because it's fixed. It is content that has been created and fixed into a tangible means of expression. The recording of this webinar could have copyright protection because it will be fixed into a tangible medium. So ideas, facts, principles, discoveries, systems, those cannot be covered by copyright. It's possible they might be able to be covered by something else. And, if you remember that intellectual property slide that I shared earlier, it could be covered by one of those other things, but it can't be covered by copyright. Short phrases also can't be covered by copyright. Maybe it could be covered by trademark, but not copyright. Works of the US government produced by government employees in the scope of their employment, not covered by copyright. Their works go into the public domain immediately. Works that are already in the public domain are not protected by copyright. And I throw this in just to have, as part of the thought exercises, think about who is left out of the process because work is not covered by copyright. And I'm not sharing this to say that maybe it should be covered by copyright or it's bad that it's not covered by copyright. It's just the information of to think about, when in 1790 in the United States, nothing I created could have been covered by copyright because I was not considered to be someone who could have their work protected. And that's just the fact of, the way things were at that time. And there are also other things, other elements that are not covered by copyright. And I, just want to share this to have us kind of think about why that is. Why is that? Oral histories, because they cannot, there's no way of those things being fixed. I often hear some Indigenous leaders talk about the fact that an oral history is fixed in the person with whom it's shared, but that's not something that could be covered by copyright. And again, I'm just, sharing this just to say, isn't that interesting and something to think about? More on the public domain. Some of your work and the content that you're thinking about including as part of this grant could be covered by the public domain. That content could have lost copyright protection or never had it in the first place, or copyright term has expired. So the public domain is a term of art, a legal term of art that means information, knowledge, discoveries, creations that never or no longer have copyright protection. And this is distinct from publicly available. So most of the things that you might find online, on the internet, those things have probably copyright protection. Somebody has made it available to you for you to be able to see, but that doesn't mean that they have relinquished their copyright unless they clearly state that somewhere. If there are things that have been digitized and made available, you do have to be mindful of thinking of the underlying work, what is actually being made available, what is copyrighted within that imagery. I have a slide here that shows a poster of Night of the Living Dead, and I share it because it's an example of someone who the producer did not follow the appropriate formalities that were in place at the time that this film was created, which was that they needed to have a copyright notice affixed to the film somewhere. And because they did not, when they first publicly showed the film, it went into the public domain immediately because it didn't have what was required for copyright protection at the time. So if any of you work in particular spaces where you might encounter or work with copyrighted materials, the number 1923 might be etched on your brain of what things are in the public domain, written, published works in the public domain before 1923. I'm here to tell you, you got to get rid of 1923 as a number, as a marker, because as of 2019, the number is going to change every year until it gets on the same schedule of what we are currently, the current regime, copyright term regime that we're on now, which is life of the author plus 70 years. So anything works in the United States published before 1930 are now in the public domain. And then next year, beginning on January 1st, 2026, everything published before 1930 will enter into the public domain. It's just going to keep going and keep going, again, until it catches up with the current term of what's happening with our current copyright terms. And then something really exciting that happened because of the Music Modernization Act, as I mentioned before, having a public domain for sound recording. So now works that were published before 1925 are now in the public domain. It can be a little tricky to figure out when something might fall into the public domain when you're dealing with things that are from the 20th century. And it's important to note that this is for the United States. There are different formalities and expectations in other countries, but I'm speaking specifically about the United States. So most things published before 1930 are in the public domain. 1930 to 1977, which includes Night of the Living Dead. That time, there were formalities that were in place that had to be done in order to have copyright protection. So there were other formalities as well, certain standards for renewal, certain standards for registration. And if you didn't meet that, your work could have gone into the public domain in that time period. 1978 to 1989, we were trying to get ourselves aligned with the Berne Convention and trying to do the rights and responsibilities that were necessary to participate in that. And so there are different conditions that might apply to that time period. So it really matters for you to be able, you will need to be able to do some research maybe on some of the content that you might have if any of your materials falls into these dates. On or after March 1st, 1989, we are officially part of Berne Convention and we have changed our term to life of the author plus 70 years. Corporate and anonymous authorship are 95 years from first publication or 120 years from the creation date, whichever is first. And again, this the one area that I have circled here is the kind of hard period to try to figure out what were the standards that were in place at the time, and then figuring out whether or not what work you might be looking at or considering, what content you might be considering, if they met the formalities that were required at the time, can be difficult to figure out. I know the Library of Congress and the Copyright Office, as well as many other stakeholders, have been heavily invested in trying to help ease the confusion on how you figure out whether something was registered, whether something was renewed. It can be very challenging to figure these things out. So I talked a little bit about whose work is not covered by copyright law, or what types of works are not covered by copyright law. But it's important to also think about who is a copyright owner. Generally, the person who creates or is the author of the work is the copyright owner. An exception to that is works made for hire. So work that you create as part of your job duties would be the actual property of your employer, not you, unless you have some kind of arrangement to the contrary, which is what I have here with the exception to the exception. In academia, higher education, many institutions do not claim copyright in academic scholarship. So they let that go with the people who are creating that content, mainly because they don't want to manage it. A lot to do with freedom of expression and freedom to study what they want to study. And also because they want faculty to produce whatever scholarship they're interested in producing, and they don't want to be involved in managing the copyright of their publications. So, it's important to know what ownership standards are set at your institution. Like, what does your institution say about that? They may have a policy about creators and creatorship and who owns what, and you should be clear on what that language says. Copyright can be held jointly. It can be transferred or assigned. Ownership of copyright is distinct from ownership of the material object. So your particular institution, agency, school, what have you, you may have something physically, but that doesn't mean that you own the copyright or can make decisions around copyright for that material. So now it's important to note that copyright is automatic. The formalities that were required sometime during in times past are no longer required. As part of joining the Berne Convention, we have agreed that those formalities are not requirements. They are optional. So if you want to register your copyright for particular materials, you can do so, but you do not have to. You automatically have copyright as soon as it's fixed into a tangible means of expression. You actually have to do something in order to not have copyright protection. So, think about what that means. Your emails have copyright protection. Your Facebook rants have copyright protection. Anything that's fixed in a tangible means of expression could have copyright protection. So as with these examples of emails, Facebook rants, Instagram posts, etc., having copyright protection, if you're thinking that could make it very difficult to know, who owns what, because things make their way around on the internet, right? So yeah, that's true. So it is more difficult actually to know who owns what because of the way we are able to interact with social media, the way we're able to share our content in different ways online. So yeah, automatic is good in lowering the formalities that are required. So the formality of having to register, having to pay, but there was something to be said for those formalities because when you registered, your name is associated with it. You have the date that you created that item and material is made available in, some roles, which, have now been digitized and now are available for people to be able to search through. But now that it's automatic and it's, in ways where maybe it's not as easy to figure out who might be the owner of something, that can also be a little complicated. So we talked about the duration of copyright already, but just to harp on it a little bit more, life of the author plus 70 years. If there are more than one author, it's life of the last surviving author plus 70 years. And as I've mentioned a couple times, now there is a copyright term for sound recordings, now that there is federal protection for pre-1972 recordings. The public domain terms are here, and generally it's 100 or 110 years from when they started. This is an attempt, again, as mentioned, to try to get these sound recordings in line with what is our current standard for copyright term. And so these will be in place until they are eventually on the same term and same time period as things that are now being created and going into a copyright term. So just to break down, what does all of this mean? Once something is fixed into a tangible means of expression, it's automatically covered by copyright law. You are the copyright owner unless it was created as a work for hire or there's some other arrangement that you have agreed to in order to have it be someone else's. The author is the rights holder unless they transfer those rights. Tangible includes the internet. Those things are also covered by copyright. And that the rights will eventually end. It seems like a very long time, but they will eventually end, and then work goes into the public domain all the time. Now I want to go into using materials and how you can make use of materials in your collections. So these are some sections in US copyright law that help cultural heritage institutions with content that's in their collections that they may not have created. So fair use is one. Hopefully you all have heard of fair use. Reproduction for libraries and archives. First sale doctrine, which is what allows most libraries to be able to lend works and materials and to acquire materials to lend them. Classroom display or performance, which is an educational exception, which allows for the use of content in face-to-face setting and in online settings as well. The online settings part is a lot more restrictive and face-to-face is less restrictive. So why does it matter how we use other people's content? There are criminal and civil penalties. And now, as I mentioned earlier, there's a copyright small claims board. There are a number of ways that a rights holder who may be concerned or offended or not pleased with how you're using their materials may want to come forth and possibly institute litigation or a claim in the small claims board against you or your institution for copyright infringement. The context of the use matters. So whether you're online or you're putting content online or using it in an enclosed environment. So those enclosed environments can include face-to-face teaching. It also could include course reserves, closed systems, things that only a certain amount of people could utilize, as opposed to things that are made openly available on the internet, through something such as like a YouTube or streaming service or something like that. One of the ways to be able to use material is to ask permission. So you find out who is the rights holder and try to request the broadest amount of permission as possible. So if you're thinking, I'm going to use it for this particular use, then you can get permission to do that. And whatever possible other ways you might utilize that content, to think about those ways and try to get that permission. Get it in writing. Email is okay. If you have a face-to-face conversation with someone and they say it's fine, follow that up with another written notice, written clarification and information about what you plan to do. So permission is one way to be able to use the work of someone else. Another thing that's available to anyone, individual, institution, is fair use. So fair use is Section 107 of US copyright law. It allows using a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, and research, and this is not considered an infringement of copyright. As I started in the beginning of this, copyright is about balance. So there is a tug and a pull between the creators and the public. So fair use is really trying to capitalize on that so that there is some type of balance between people who are creating materials and content and other folks who are using those materials. So some things are good for being able to copy, to make commentary, to teach on something. We are both creators and consumers of copyrighted work, so there needs to be some give and take, and fair use helps with that. Fair use has 4 parts to it that, as you're going through the 4 factors, you would analyze how you're intending to use somebody's content and then have a determination of whether your use could be a fair use or maybe is not a fair use or leans away from fair use, I should say. The first one is talking about the purpose of the use. So what are you doing with this content? Are you doing something that is transformative, that is different from the original use? Is your use commercial or non-commercial, educational? What is the nature of the work? Is it fictional works or fact-based work, published work, unpublished work? The amount, how much of this work do you plan to use? And is it only what's necessary to serve your purpose? And lastly, whether there would be a potential harm, market harm for the original owner or the rights holder. And this is to do with the current or a potential market that the rights holder might be involved in. Some of you may be familiar with the fair use checklist. Dr. Kenny Cruz, originally at Columbia University, created a fair use checklist, which was based on court cases, which I'm going to go into a few court cases, probably maybe after, I might be able to get in one before we go into the break. But we use these to kind of go through when we're considering content that's not our own content, that's someone else's material, that's still in copyright, considering whether the use that we're participating in either favors or opposes fair use. And again, this checklist put together is based on cases that have gone through the federal courts to determine whether or not they were fair use or not. So I think I may be able to get through one case and then we'll come back and finish these, the cases that I wanted to kind of go through, to go through the 4 factors of fair use. So you can kind of think about how these might apply to some of the content that you might have in your collections. So the first case I wanted to talk about, all of the factors, the 4 factors of fair use, all of them are important. But there are certain cases where it kind of turns on one particular factor, not to the detriment, but in concert with the others, but there's like one kind of thing that kind of got through on a particular factor. First case is Campbell versus Acuff Rose Music. Some of you may be familiar with Roy Orbison and both Two Live Crew. They make wildly, vastly different music. And in 1989, Two Live Crew wanted to make a parody of Roy Orbison's Oh Pretty Woman. So they wanted to make a parody of the song. They originally reached out to the music label and asked for permission to be able to make their version. Two Live Crew, if you don't know or not familiar, please don't use your work computer to look them up. But you can find out information about them. But they are a rap Miami-based group, and they do a lot of pretty raunchy music. Roy Orbison is a 60s balladeer. So they wanted to make us do a song that made fun of the song that Roy Orbison created. They asked for permission, and they were rejected several times. They decided to go ahead and do the song anyway. So they made their song, and the music label representing Roy Orbison brought litigation and went several rounds in circuit court and eventually ended up at the Supreme Court, where the Supreme Court determined that the Two Live Crew's use of the music was transformative. So this is the first time we hear the words transformative with fair use. And it was a case that was very, very interesting in how the decision came down. The Supreme Court said, this is what they needed to do. They used only what they needed to show that they were poking fun at the song. There was the transformativeness was in that the song was a satire, a commentary on the original song. And it was different because they're different audiences. And it also said that the market would not be harmed for Roy Orbison's song because those markets are vastly different. So they found for Two Live Crew, essentially saying that it would be unlikely that the artist would have the same audience and that one person would mistake one song for the other. Again, you should listen to the songs if you haven't heard them both, maybe not on your work computer. Let's see, I might be able to get to one more. Let's see. So I wanted to actually put this case in too, because it's another case that was decided on the first factor, because actually one of the parties decided to go to the court first to ask for a ruling on the transformativeness of the use. So in this case, it's Warhol v. Goldsmith. Lynn Goldsmith was a photographer, took the photo on the left. Andy Warhol somehow got hold of the photo and made the series that you see on the right. And once Lynn Goldsmith became aware that her photo had been used to create this series and that Andy Warhol and his foundation had made a lot of money off of that, she approached them to say, this is my original copyrighted content. You need to make sure the copyright of this material comes to me, and any money that you've received comes to me. They did not appreciate that at the Warhol Foundation. So they actually started the litigation and asked for the federal court to say that how they used the material was a transformative fair use. They asked for this ruling on the first factor only. Usually most court cases, when it's a fair use case, they will go through all of the 4 factors, but they were asking for a specific ruling on just the first factor. This case also ended up in the Supreme Court. And the court said that the use by Andy Warhol was not a fair use, that it was not transformative, that they were doing the same thing. They were operating in the same space. The one picture on the left taken by Goldsmith was intended to go into a magazine to sell magazines. The second image, which you can faintly see highlighted there, the orange prints was used to also sell magazines and to show a face of Prince. And so the court said this was not a transformative fair use and ruled against Andy Warhol in that case. Okay, so I will pause here for the break, and then we'll come back and finish with the third and fourth factors.
We'll be back in 5 minutes at 2:51 p.m. Eastern.
All right, welcome back. All right, so I misspoke. We are starting with the second, third, and fourth factors, but let me just get through these pretty quickly, and then we'll get into some other considerations around ethics for your collections. So in factor 2 is dealing with the nature of the work. Those of you who are maybe history buffs, US history buffs, may be aware of like this particular case, Harper and Row v. Nation Enterprises. President Gerald Ford wrote a memoir, and his publishing company negotiated to be able to share a blurb, a short version of this with the magazine, and that they would be able to basically have a scoop of information that is contained in the memoir. So this work was not yet published and had not yet been released, but they were given a scoop to a particular magazine. The Nation came along, somehow got a hold of those unpublished memoirs, and they went ahead and published an article before the other magazine could get theirs out. And so the publishers of A Time to Heal, Harper and Row, came forth with litigation that ended up in the Supreme Court, basically saying that they use what was essentially the heart of the work of the publication, the memoir from President Ford, where people would be probably most interested in getting that particular book is to know why he pardoned Richard Nixon, former President Richard Nixon. And they went ahead and published that in their publication before the publisher or their authorized the other magazine they authorized would be able to publish it. And that really basically ruined their market for their ability to be able to be successful with the book and to sell the copies that they wanted to. The Supreme Court found that the unauthorized reproductions of excerpts of the unpublished memoir was not a fair use. And that the unpublished work, that the fact that it was unpublished was really key to negating the fair use defense, because they were like, you knew that this was a key, very much the very heart of the work, and why people would be interested. So the amount was also in play as well, because they were saying that, you know, most people who were buying his autobiography probably wanted to know a lot about what was happening with the Nixon pardon. So that was one where factor 2 was very much at play. Next, factor 3 is talking about the amount, also dealing with kind of the heart or the main parts of the work, which we talked a little bit about in the previous factor, but that one mostly did hinge on the fact that it was an unpublished work. With factor 3, dealing with the amount, this is Bill Graham Archives versus Dorling Kindersley Limited. This did not make it to the Supreme Court, but it did go several rounds in federal court. And essentially what happened here was there was Bill Graham Archives owned the copyright for the rock band, the Grateful Dead's concert posters and tickets. Dorling Kindersley Limited actually sought permission initially to reproduce images of 7 posters for a cultural history book about the Grateful Dead. They did not get permission, and they went ahead and displayed these 7 posters in the book that they created. Bill Graham Archives brought litigation, and the court said that the use by Dorling Kindersley in their book was fair use. They basically said that they were using the concert posters as historical artifacts about the Grateful Dead, and it was a transformatively different purpose. And they also did, while they did use the posters in their entirety, they reduced them in size and had them as part of like a timeline, which was telling a story about the Grateful Dead. And they were not using them in the exact same way the original posters were being used. It was really to show this historical perspective. And while they did use 100% of the poster, they needed 100% of the poster in order to fulfill their purpose, and that this was a fair use. So finally, the final fourth factor deals with the market effect. And this is Cairo v. Prince, also did not make it to the Supreme Court, several rounds in federal court. And you have Patrick Carriou, who created a coffee table book called Yes Rasta, with very tasteful, beautiful art, photographs of Rastas in Jamaica. And Richard Prince, who is a well-known appropriation artist, took several of the photos from the coffee table art book and made what you see on the right side of the screen. The circuit court said that this was a fair use, and that there was no concern for the market because they had different markets. So someone who was looking for, these beautiful photos of Rastafarians is probably not also in the same market for whatever this is from Richard Prince. Not one of my favorite fair use cases. You can ask me a question about that later, but yeah. So this was found that there was not a market harm because they had different markets. So application of fair use, what do these cases mean to you? That there are a lot of myths that still persist, even though, people have been talking about fair use for a long time. You might have heard 20%, 10%, 6 seconds of a song, 10 seconds of a song. If it's educational use, it's fair use. Commercial use can't have a fair use. Any use is transformative. If it's socially useful, that's fair use. And you can't do fair use if there's a permission scheme involved. Several of the cases that I talked about here, doing a little bit of just a little information about these different cases, sometimes the people asked for permission and they either weren't given permission or nobody responded to them. And they still went ahead and used the material and then got a ruling in court that it was a fair use. And we know from, industries across all the different artistic industries have to rely on fair use in order to do some of the work they're doing. So some of the largest production companies, movie companies, music labels are all relying on fair use. And they're definitely not hurting for money. So how do you determine fair use? You're going through those 4 steps, and as I mentioned, all 4 are important to kind of talk about and think about when you're wanting to make a case for fair use. So what is the purpose? Why are you using this particular thing? Could you use something else, or does it have to be this particular item? The nature of the work, fiction, nonfiction, highly fictional things have a greater protection. We've seen that in the courts where they are wanting to protect things that are, not factual, but something that somebody created with their mind. They want to be protective of that. So you really have to show that there's a purpose for why you want to use this particular thing. How much of it are you using? We saw some evidence with some of the cases that sometimes they're using 100% of the work. And sometimes that is necessary to fulfill your purpose. Sometimes people are only using what exactly they need to be able to make their cases. And then lastly, showing whether there's some market harm for what it is that you're doing with this material. Could you harm a current or a potential market for the creator? Another part of US copyright law that's beneficial for cultural heritage institutions that are archives and libraries is Section 108. So this is where we are allowed to make copies of certain content. It covers libraries and archives. It does not cover museums. And so many museums may look to see if they could do something under fair use because Section 108 specifically does not include them. Things that are permitted: isolated and unrelated copying and distribution of single copies of work, literary works, other types of works. It depends on what it is that you're doing under Section 108. If you've had an opportunity to read Section 108, you'll know that this is a very abbreviated version of it. It is very long. It has a lot of caveats. But I mentioned it here so that you know, like, that there is a right that's available for libraries and archives, and specifically mention libraries and archives in U.S. copyright law. The conditions that where you are able to make copies as a library and archive is that that you have no information or no knowledge about commercial advantage, that somebody comes to you and says, oh, I'm going to use this in my movie. I'm going to use this in my book. I'm going to use this in, something sounding very commercially. Then you would know I can't rely on Section 108 to be able to make whatever copies they've been asking for. Your collection, your library archive has to be open to the public and available to researchers. Reproduction and distribution of this work has a copyright notice, provides information to folks about copyright, that the material might be covered by copyright. That is very important to be able to rely on Section 108. Another thing to consider in your collections is that there might be something else. So we talked about, getting permission. We talked about the rights you might have under U.S. copyright law, fair use, Section 108 if you're a library or archive, but you might have things in your collections that are copyrightable materials that have some other type of restriction. So if things were donated and it has some kind of restriction in that donation agreement. If you are sending things out to third parties and digitizing materials, are there some restrictions on that material? Licenses for e-resources could have some restrictions as well. So these are things that you should be thinking about. If you have items that have been donated that are still covered by copyright, are there restrictions that might have some impact on how you reuse that content? Okay, so the last part of my section, my presentation today, is to do with the collections that you have and to think about how you're using the content and how, what is your content and how are you making uses, how do you want to make use of that material? And this is just really things for you to think about. Some of it, it's like, I feel like this is the slides of questions where I have a lot more questions than I have answers or solutions, but it really is for you to think about what it means for your collection as some of these points that I'm going to raise. So what is in your collection? What are you collecting? Audiovisual materials, text, artwork, artifacts, cultural heritage. Obviously, not everything is problematic or have some kind of issue with it, but there are some things that maybe reserve a lot of thought and thinking about what's in the collections. Recently, in some conversations I've been in, people have been like trying to remember that sometimes your collection is really humans in the collection. And I don't mean remains, although I sometimes mean remains, but that there are representations of people, of family, of community in your collections. And what is it that you plan to do or want to do with that material? Why do you collect this material? And some of that could help with your mission, with your principles, with your guidelines on how you make other types of uses of this material. We're collecting all types of stuff. As mentioned, I'm at Yale Library. There are so many different types of materials that are in our collections. We are collecting it for a variety of reasons: research and education, providing access, preserving materials. And also, because there are responsibilities that we might have to donors who are providing some of the materials that we have. Some people see that there is in providing certain types of access to certain types of materials, there's some element of justice or social justice that might be kind of driving why we're collecting certain things or have certain things in our collections. The issues you might want to consider intellectual property rights and not just copyright. There may be things in our collections that have to do with patents or trade secrets or trademarks even. What, you know, copyright is definitely an element that should be considered, but there may be some other issues that are of concern in what might be included in your materials. Privacy, moral rights for artists, cultural heritage items, ethical issues, issues around repatriation, whether that is digital repatriation or physical repatriation of materials, all things to think about. So I also like thinking about, I know I said I'm not only talking about like kind of uncomfortable things in our collections, but you know, there are probably in everybody's collection, I know for sure there are here, uncomfortable things that we have in our collections. And, you know, we do need to think about what it means. And this is really at the heart of what I'm saying when I'm talking about human representation in your collections. So some of you might be familiar with the documentary film, came out a few years ago, Three Identical Strangers. It had to do with a twin and multiple study that was done. I actually don't remember what institution was behind it, but it was a study that was done where multiple birth children were separated at birth. And the study was looking at the different outcomes that came from the separation. So there were twins who were separated, triplets who were separated, and then they were studied and to see what happened. So there are all the records related to that study are here at Yale, and they are sealed until 2065. And I genuinely and sincerely hope that I'm not still working at Yale in 2065. But something that I really think about is like, what will happen in 2065 or 2066 if we decide to open that collection? The thought of having it sealed for so long is, you know, around maybe it's we need to know that people who are involved with this, maybe they're no longer around or no longer alive, and maybe it's okay for this information to be released about them. I don't know. I mean, they may be deceased or not around, but what about people who are related to them? Is it important to think about how this could impact them, how the records around this could impact the family members who may be behind? Another case on the right are images of enslaved individuals who were taken by a noted racist from Harvard and taken in the mid 19th century. So these were enslaved people who had no ability to consent to their images being taken, the photographs being taken of them, and then housed in a closet at Harvard for many, many years until they were discovered in 1977, I'm sorry. And then, you know, made available in different ways. And one person who has stated that she believes that she is a descendant of several of the enslaved enslaved people who were included in these photographs, came forth and said, "This is my family. Why are they included in your collection? And you've made them available online in this way." So she brought litigation against Harvard. And so there are things where we just need to be thinking about, like, why do we have these things, and what is the mindset for how we share or make available this type of material. Other issues are happening in regards to collections from Native Americans, items that have come from other countries that have somehow made its way into our collections, and maybe it wasn't supposed to be, maybe it got there by mistake or somehow got acquired. But now, you know, there are conversations that people are having about, you know, why is this thing in your collection? Why do you have this material? And wanting either it to be returned, wanting it to be repatriated, wanting to have some type of repair for having certain types of material. And I'm sharing these different little stories just as a way for you to be thinking about the things that you have in your collections and like what it means to digitize that material, to make that a material, whether you make it available openly online or you make it available, you know, in your reading room or at your facility, however you make it available, thinking about, you know, what it might mean to a particular community or individual families or persons who might be related to anyone who's featured or any items that are featured. One of the last vignettes I wanted to share is, you know, the other part of sometimes having this content or so what I would still consider to be like problematic kind of content available is that there is an opportunity for people to try to even intervene when they have no connection to do a repair to something. So the photo on the left is an artwork that was done by Mary Enoch Elizabeth Baxter, and she came across a photograph that was listed openly online on the Pennsylvania Academy of Fine Arts website. It was a photo of a naked child, and it was taken by Thomas Eakins. She came across this photo. She contacted the Academy and asked why was this photo just available online of a naked little girl just sitting there. And they really hadn't even thought about it. Like they really, until she raised this issue, this photograph had just been on the internet. And so she is, as an artist, created artwork. I'm not sure if you can see it very clearly, but she inserts herself into the photograph to cover the little girl. And there are other artwork that she's done where she is putting a blanket over the child. And so this is an attempt to kind of reframe to provide protection to the girl. But this is, you know, a thing that I'm raising just for us to think about as the, you know, sometimes I feel like the material that we put across becomes data, becomes information that is disconnected somehow with what it's human connection, it's human ness. And so like, I want us to be thinking about this as we're thinking about some of the content that we might be contemplating, including in some of the grant applications and including in our collections in general, even if it's not a part of anything that you might be thinking about. I talked quickly about, you know, sometimes there are human remains in our collections. You know, if you're familiar with the MOVE bombing that happened in Philadelphia, you may have heard on the news of several collections in the Philadelphia area who had remains of people who were affected by this bombing. It's unclear to me why they had remains of people who died, you know, after the police set off a bomb in a neighborhood. And you should look it up. That is what happened. And, you know, so they've only now been finding out that these remains were not buried. They were in classrooms and being studied in libraries, in archives, in places that they shouldn't have been. And so I think part of it is like a disconnection that people have to items that are in our collections where we are somehow not seeing the humanity that's attached to it. So there's a lot of work that's already been happening among libraries, archives, museums around you know, the things that we have in our collections and in places where they're building collections. And I think it's important to think about whether your organization, your institution, your place of work, whatever institution you're involved with that may be submitting something, are you part of the community that your collection might impact or affect? I understand that the community is not a monolith. You know, there may be different parts of, you know, that want this or want that. But are you in community with them? Are you having conversations with them? Are you thinking about how you represent that community, how you represent this collection? Recently, there's been a lot that we've seen about repatriation, actual physical repatriation, sending things back to the community from which it came, or working with community to do digital repatriation, where people are allowed to have digitized representations of the content, or vice versa. The institution keeps a digital copy and the community gets the physical copy back. Restricting or limiting access to materials, another way that through conversations with community to determine like what should happen with this material. So in my last couple minutes before we open it up to questions, I just want to say that when we're thinking about how to reuse materials, as if we are the rights holder of materials, there are some ways in which we can make works available online to let people know how they can reuse that material once they found it. So with rights holders, you can use Creative Commons. You may have seen these badges online, different places. These are actually licenses to be able to reuse materials, which is something that a rights holder can do. You can allow certain reuses of your material in certain ways. And starting from the top, the top one is actually not a license. It's a badge that's saying, we are putting this work into the public domain. We're not reserving any rights to this content. And then starting with the CC BY attribution license, that is the least restrictive license, saying that as long as you say where you got it from, you can use this material. And then going down, it gets more restrictive. When you're not a rights holder, there's some other options that are available. There's a public domain mark. So that is a mark that's available if you think that a work might be in the public domain. You may have some information that it's in the public domain as part of your collection. You didn't create it, but you think that the work is in the public domain. This is a mark that you can use on content. And obviously you would want to do it on content that you know for sure is in the public domain. There's also work with local contexts, dealing with indigenous communities and putting traditional knowledge labels on materials. And then another non-rights holder solution is using rights statements. This is also available for rights holders as well as local context labels, but these are ways in which you can provide information on how people can make uses of the material they may find on your sites. And that is my last slide. I just want to thank you all for your time and attention today. And now we have a little time for questions.
Yeah, we're going to get into some questions now. If we run out of time to answer all your questions today, we'll be sure to provide written answers in the Q&A doc that will be posted alongside the recording on the Apply for an Award page. And please note that we'll be holding a full hour-long session dedicated to questions and answers only on April 9th.
I guess we'll read out the questions, and if it's something that the program officers will jump in. First question for you, Sandra. This applies to materials formerly copyrighted. We think this is from your slide 12, but we're not sure.
Oh, I am not sure what that means.
I'm not sure what the question means either. This all applies to materials formally copyrighted. Maybe speak on the difference between formally and not formally.
Okay, yeah, I'll do that. So in our current copyright regime that we are under, which is officially the 1976 was the last full revision of US copyright law, there are no formalities that are necessary for copyright. So that's basically 1978-ish to present. The term of copyright is life of the author plus 70 years. You do not need to register copyright. You don't need to put a copyright notice on, although it is good and useful for you to do so. So if you create something, you should put a copyright notice on, or you should use some type of information or terms. If you want to set those for people, you can use something like Creative Commons to provide information on how people can reuse materials. So it is actually in your benefit if you create something and put it online to have information about copyright or have information about reuse. In the past, so before formalities were removed, there were certain things that you needed to do, and those changed over time, which is why now this is meant to be simpler and easier to have less formalities, because at the before you needed to register your copyright, or you needed to at least have a copyright notice on it. In some cases, you needed to renew copyright, and these are all official and formal procedures that needed to happen in order for you to have copyright protection. We no longer have those requirements.
Next question. Are records created by state and city government entities also not covered by copyright?
If they're creating it as a part of their job duties, it doesn't have copyright protection. There might be other reasons why it's not so readily available to you. And that might have more to do with gatekeeping or charging fees than it does to do with like copyright. So whatever is being created as part of job duties, if it could have had copyright protection, which, you know, depending on what type of records you're talking about, maybe doesn't have copyright protection in the first place. But if it could have had copyright protection, anything that's created in the scope of employment of federal employees goes into the public domain automatically. State and city copyright is different. So you would have to look up that state or city to see what rules or regulations they might have around what is created by state or city employees. And again, you do have to consider whether or not it is something that could be copyrighted.
Thanks, Sandra. Do you know if there is any documentation or resources to verify if a newspaper archive purchased by a new publisher is automatically transferred to the new publisher, or if, in some circumstances, it could be retained by an earlier publisher of the same paper? I'd like to research this practice.
That is a good question. So I would imagine if you are a publication, a newspaper specifically, and you sell the rights to the newspaper publication, that would include copyright. Obviously, I couldn't be involved or wouldn't have knowledge of like any specific deals, but I would think a purchaser would be probably most interested in owning the copyright for that material and the ability to continue to process and do whatever information sharing they're doing using their copyright, using their trademark, using, you know, whatever other intellectual property rights are involved. So if there is an archive that continues to be in copyright, then I would think a purchaser would also have purchased the copyright to that. Now, you would want to think about if it's an archive, whether some of that content has gone into the public domain. That is a possibility. So that is something that you would also want to investigate.
So keeping it basic, regarding materials in the archives, who owns the copyright? The archives or the person who created the document?
So I did a really good job of not saying it depends even once, but now here I come with it depends. So it would generally could be the person who created the material could be the copyright owner. But if you work in libraries, archives, even some museums, we get donated items all the time. And through those donations, sometimes the donors also transfer copyright. Not all the time, but sometimes they do transfer copyright. And if they transfer copyright, it does become under the copyright ownership of the archive. And the archive should be very clear on what they have rights in, and their transfer needs to have a signature. So just by virtue of them having the archive, that does not make them the copyright owner. And you should also think about in archives, there's a lot of mixed content. So it might be content that was created by the donor in which they could transfer copyright and things that they created, but they might also have things that they've just collected. They might also have things that are the copyright of someone else. They might have, if it's an author, they might have works where they transferred the copyright, but they still have copies of, this published work where they transferred copyright. But they might still have copyright in the unpublished version. So those are things that you still want to think about if you're looking at a particular collection in an archive.
Sorry, this question is kind of more of an us question, I think. Is there an ideal format or existing example format that CLEAR recommends when breaking down the various access, reuse, and rights to reproduce considerations within our proposed collection? We recommend rightstatement.org for some information about how you might want to communicate access restrictions and to create machine readable statements. We also advocate the use of Creative Commons licenses, but we don't recommend a specific format for all these projects because your projects are unique and your materials are all different, and that may depend on the needs of your materials. So you can go to our funded projects page and see some previous funded projects that may be similar to your own, but there is frequently an assumption that if you do not have full public access for everything, that is some kind of knock against you in the panel, when in actuality, the panel wants to see restrictions that are appropriate to your material. So if you have materials that have a lot of private personal information in them, they want to see that you're considering how you're handling these things. They don't want to just see blanket access for everyone.
And I'll just add to that when I've served as a grant reviewer for other grant sessions. And that's exactly right, what Allison said. We are just looking to see that there's a plan of action, that you're acknowledging some of the content may have copyright considerations or ethical considerations or privacy considerations, and that you've created some kind of plan to deal with or manage that, whether that means you have closed access or everything is not going to be available online, or you have some kind of tiered something. But we just want to see that you have actually thought about it, as opposed to, oh, we think everything's going to be fine, which maybe it might be, but we do definitely want to see that you've thought about it.
And I will say that this looks like that this applies to a question that was just asked too at the bottom. So we can just move on. But this one was, this may be more of a question for Sharon and Allison. Will our grant application be heard if we need to pursue copyright protection for images of artworks? I work in a progressive art studio for artists with developmental disabilities, and we'd like the artwork images to be accessible, but to be able to charge licensing fees for commercial use. We manage licensing on behalf of our artists. However, paper records, archival photos of studio activities would be public domain. And I think you answered that already, Sandra. Right?
Oh, and hey, Lucy.
I do want to just say about the licensing fees, we do have specific instructions in the guidelines. Just asking you to explain any fees you use, but the Creative Commons requirement is metadata only.
Yeah. As long as you put the fee schedule in there and it looks acceptable to the reviewers, you should be fine. Okay, the next question is, if one of the organizations our collections have material from is no longer active, but we have contact with former leaders, who should be asked for copyright permissions?
Yeah, that can be really, really challenging. If an organization is no longer around. If the former leaders are actually the ones who can give permission is a question that I wouldn't have the answer to. So I think one of the things to look at, because I'm sure many people might have a similar situation where either the organization is defunct or you're not able to get in touch with anyone. This might be a case where it might be helpful to look at what are you trying to do? What is like one of your goals, or what are you trying to accomplish? And think about whether fair use may be helpful for what it is that you want to do, what you're trying to make happen. One thing I've seen definitely in the past is someone will contact someone who is part of the organization, maybe leadership in the organization, to not so much permission, but to be like, this is a thing that we are intending to do. Do you have objections? They may even sometimes even go as far as, creating some type of formal agreement. In those types of instances, you do want to make sure that this is actually someone who could give you the permission that you're seeking. And, there are other instances where you might want to think about, okay, so maybe fair use is not great. I'm not actually sure who I can get permission from. Then it may becomes like, what is the risk? What is the harm that could happen? So who would be harmed or offended or have some concerns if we do what it is our goal is to do with this product? Should we, look into that and be considerate of that before we move forward? Because, this particular community may raise objections, or this particular community could be harmed by the way we're planning to operate in this space. So it is something to think about, and I am sorry that I don't have like a very good, concise answer for you, but yeah, it's definitely a thing you should think about.
All right, we're gonna take one more, and then we have a couple of closing slides. We'll put up any answers to any questions we didn't get to today. Sandra, is there an understanding of a changing definition of public domain, i.e. oral histories that we want to digitize where permission was given to place the oral history in the archive museum, but these written permissions were given pre-internet?
Oh, here I come with, it depends again. I'm so sorry. Okay, but the reason why I would say it depends here is depending on when these record. So I'm assuming you have something recorded that you're utilizing. So if you do have something that is recorded and there are some concerns that you might have, if it's possible to get permission from the folks who were recorded to say, here's a different use that we're actually planning to use for this material. Is it allowable? You might also consider, if you have those like the permissions forms or license forms that you had to record the person to take their oral history, kind of having someone, maybe a lawyer, or maybe your general counsel, if you have one, to take a look at that to say, is there anything that we could do? Is there any wiggle room in this agreement that could allow us to, if the desire is to make things available online or make things available in the reading room, or whatever it is that you're thinking of doing, you might want to ask, like, as you're reading this agreement, do you think there's any space for us to do the things that we want to do now? This is a plug for, when you're seeking permission, in the beginning, to try to think as broadly as you can. I know sometimes it can be hard to think as broadly as possible. And then sometimes you are just receiving something where you had no involvement with the collection of that information. And so you couldn't have asked for what you need for it now. But if you are the one that's in charge and you're creating a form, you want to think about like all the broad possibilities of uses that you might have, so you don't have to try to go back and try to find the person to try to get this extended permission that you want to have.
All right. Thank you so much. We just have a few quick reminders before we end. First, we want to do a quick poll to see how you're feeling now about today's topic. So we'll take a minute if you can complete that. Getting a couple more. Why that's happening. I just want to thank you for your participation and feedback. As you work on your final application, remember there'll be 3 additional sessions over the next month. The next one will be on March 19th, and we will explore how to assess your collections and design a sustainable and achievable digitization plan. And you can sign up for this session on our Apply for an Award page. And I also want to make note of the survey and that we dropped in the chat. If you can take some time to complete that, we look forward to hearing how this session went, what you might like to see in future sessions, and how we might improve. Please don't hesitate to send questions to the Clear Grants team at hiddencollections@clear.org as they come up between now and the final submission deadline of May 5th. Thank you. We want to extend a huge thanks to Sandra for leading. And thank you for joining us today. And we hope to see you at another session soon.
Thank you very much for having me, and thank you all for your great questions.